Thank you, Mr. Chair. I appreciate the patience and understanding. Just returned from presiding over the Senate. There's a vote open, I'm sure you're aware, so we'll be making our way soon, but wouldn't want to miss this opportunity to offer some remarks. I appreciate you and Ranking Member Graham for holding this important hearing. As we've discussed this morning, the ERA is and always has been about addressing sex-based inequality. For generations, women have had to fight for access to some of our most basic rights. And in my view, last summer's Dobbs opinion was significant. Across the country, Americans have made their opposition loud and clear. And as we work to uplift their voices, we must ensure that we remember that what is at stake here. Rights once recognized by the Supreme Court and held dear by Americans may no longer be safe unless they are enshrined in the Constitution. I know some of our colleagues on the other side of the aisle talked about, well, what's the issue? What's the problem? It's already unlawful in America. It's already unlawful in certain states to do X, Y, and Z. But we know those rights can easily be compromised. So with that in mind, a modernization of the law to recognize sex equality is needed, and the guarantee of equal rights for women is non-negotiable. As we analyze this issue, I look forward to working with my colleagues to end sex-based discrimination in our country once and for all. Now, I did have a question if Lieutenant Governor Stratton is still with us. I know she was participating virtually. Before becoming Lieutenant Governor of Illinois, you served as a member of the Illinois House of Representatives and were a leading advocate for the bipartisan vote that ratified the ERA in Illinois. Wanted to describe your perception of the future of equality in America and what the impact the ERA ratification could have on future generations.
Thank you so much for that question, Senator. I think the most important thing that I want to emphasize is that the Equal Rights Amendment will remove ambiguity and will make it abundantly clear that no one should be discriminated against on the basis of their sex. We have made progress, and we've heard today, yes, there's been progress made. Of course there's been progress because there's been a lot of women for many generations who have been fighting for this progress. But we have to make sure that we not only keep the progress moving forward, but that we protect any attacks on the progress that has already been made. That is what we talked about on the floor in 2018 in Illinois in that bipartisan vote. And that's why the Equal Rights Amendment is so important, to provide a constitutional safeguard to prevent any efforts to roll back the gains that we have made towards women's equality.
So thank you. I just want to make sure I get in at least one more question with my time remaining. Enshrining an explicit guarantee of sex equality in the Constitution would provide the strongest protection against sex-based discrimination. Unfortunately, state and federal legal protections are vulnerable to future attempts to undermine women's security. And we need to look no further than the recent bills being introduced across the country targeting women's access to abortion care. Question for Ms. Sullivan. In your opinion, are judicial remedies like the Equal Protection Clause and the Due Process Clause strong enough to protect a woman's right to abortion access and care?
Senator, the Equal Rights Amendment will guarantee that women are equal to men. It will not determine for all time difficult debates in our country, like debates over reproductive rights. Constitutional rights are always subject to a balance, and I have no illusion that the ERA will end those debates. But Senator, it will guarantee equality. It will guarantee equality, that women can't be treated as lesser than men. And this body has the chance to, as the Lieutenant Governor said, remove ambiguity. Who would answer the question, are you for or against equal rights for women? Elsewhere in the world, there are people who would say they're against it. In this country, no one would say I'm against equal rights for women. So why not remove ambiguity about that? Why not remove ambiguity? And ambiguity is all that led the DC Circuit to act today. They said it was not clear and undisputable that Congress can that the congressional deadline is incapable of binding the states. Make it clear and indisputable. Pass Senate Joint Resolution number 4 and remove any doubt about that deadline. Conservatives tend to like two things, Senator. They like looking at the text. Article 5 has no deadlines. And they normally like states' rights. So why not allow Illinois, Nevada, and Virginia to deliver us into the modern world where we, like other nations of the world, have equal rights for women, as you said, Senator, enshrined in our most foundational document?
Well, thank you very much. Wish we had time for many more questions and much more discussion. But on behalf of Chairman Durbin, I want to thank the witnesses appearing before the committee today. Today's hearing makes clear that we have waited far too long for the Constitution to finally, explicitly recognize that equal rights should not be denied on the basis of sex. Tomorrow marks the beginning of Women's History Month. There is no better time to move forward on this joint resolution. Remove the arbitrary deadline that has held equality at bay, and once and for all enshrine equality into the United States Constitution. And with that, this hearing is adjourned. Thank you.